Hi, everybody. I'm Gwendolyn Sterk from Sterk Family Law, and I'm privileged to have attorney Keshia Bardney with me today from our office. Hi, Keshia. How you doing today?
Hi, Gwen. I'm doing great. How are you?
Good, good. So I wanted to talk to everybody about relocation. It sounds like a real crazy word, but before we ever get started on that, when we're dealing with parenting issues today, we are now more PC, for lack of a better term, and we call it allocation of parental responsibilities. Can you tell everybody what that means?
Yeah, so that's what Illinois law refers to as who makes the important decisions about the best interests or the well-being of the child. So that's where the court determines healthcare, education, upbringing, extracurriculars, all of the decisions that you would make for your little one. That is when that's determined, and that's what that includes, as well as parenting time. So what the schedule looks like during the school year, during the summer, and different holiday breaks, that's all encompassed within that term.
Right. And I guess it's real important to make sure that people don't refer back to it as custody anymore, because we got rid of that term as well as visitation. So we now call it the allocation of parental responsibilities and parenting time. Well, that becomes a real interesting topic, because then we have to deal with relocation under the statute, which was previously known as removal. First, can you tell us what is relocate? What does that even mean?
So relocation is if a parent wants to move from their current residence. And that could be within the same state, that can be out of the state. But when it comes to children, there is labeled relocation, formerly known as removal, as you mentioned earlier, just because there's a change in residence or change of location for the child and the parent.
Now, do you always have to get permission from the court, or if you move across town, does it matter?
Well, no, the law does indicate a radius. So within certain counties, Cook being one of the main ones, in Illinois, there's a 25-mile radius that if you're within that 25 miles from where you currently live, not just 25 miles regardless, it's 25 miles from where you currently live. Then if you stay within that realm or that distance, then you're good to go. If you do decide to move outside the 25-mile radius, if you have an agreement by the other parent to say, hey, it's okay for you to move, then you don't necessarily need the court involved. It's when there's a contested issue by the other parent that you may have to ask the court for permission.
Just so I make sure that everybody knows, it's Cook County. And then also if we have the surrounding collar counties, like we have Lake County, DuPage, Will, all of those counties as well, whatever's a collar county, a Cook, it's 25 miles, correct?
Correct.
Now, what if you're in rural Illinois? Let's say that you move and you live somewhere in Southern Illinois. What's your radius in that event?
So it's double the size. So it's about a 50-mile radius. So if the same thing applies. If you move 50 miles from where you're currently living, then you're good to go. If you're outside of the 50-mile radius in those rural counties, then if there's an agreement by the parent, then also you're good to go. But again, if it's contested, you're 51 miles and more from where you're currently staying in those rural counties, then you may have to ask the court for permission.
Now, it's interesting to me because, today my ex says, oh, it's okay for you to move, and tomorrow they change their mind. So is there a process, if there is an agreement, to document really the ability to relocate? And how do you notify the court of that to make sure that somebody doesn't change their mind?
Well, one of the things you want to do is get a written notice. You provide that to the other parent, basically outlining where you're moving to, just giving enough information so they know where the child is going, how far out it is, what the address is, all of those details so they know how to locate the child. And then you may ask for their signature or their agreement, or you can ask that you guys update the allocation judgment or the allocation of parental responsibilities judgment to reflect that this is the agreement between both of you.
Now, if you get that notice, though, so you provide the notice and there's a signature back and you reached an agreement with the parent of the child, all you have to do is file it with the court, right? And then it's binding.
Correct.
And that's real interesting, because I think a lot of people don't go through those notice proceedings in the first place. And that's really the first step that they've got to do. Yeah. I guess the other question is, what parent qualifies to remove a child or to relocate?
So usually if you have equal, so 50-50 parenting time or the majority of time, so exceeding that 50%, then you are eligible to apply for relocation or motion to court for relocation. If you're the other parent that has, less than 50% or you don't have the majority of time, then it may be an issue for you to petition the court for relocation because
Right,
you're
you
not
really don't have the ability or standing
right.
to do it, right?
Right.
And I think that's interesting. So if you, for example, live out of state, you've always lived out of state, the other parents always had the primary time, you can't then just file a petition to relocate that child to your state.
Correct.
You would first have to move to reallocate the parental responsibilities and the parenting time, get the majority of parenting time, and then go for relocation. Do I understand that correctly?
That's correct, because there's no need to ask the court to move a child in a location that they had never really been in primarily. And then to try to switch that up is going to be an issue, and you have no standing, as you mentioned before, because that child has never been there for the majority of the time.
Now, let's say that you get permission and you're going to move, you live in Cook County or Collier County, and you're going to move 27 miles, you give the notice, you give permission. Now, that doesn't mean that the parenting time schedule has been modified though, does it?
No, that's just, you're just moving. It doesn't affect the decision making. It doesn't affect the schedule.
And so that might be a reason that a parent who's responsible for transportation or shares transportation may be unwilling to agree to it because it may influence the amount of time they have with the child.
That is one of the reasons, especially if they're the majority transporter where they're going back and forth. It may create a strain on having parenting time with that child. So that's usually one of the main factors that play into relocation or the contest of relocation.
Sure. And if you think about it from a parent's perspective, I mean, if you have to pick up the child after school and you're able to do it and you live in the same school district, now suddenly the parent with the majority parenting time wants to move 24.5 miles away, you getting to school at the end of the school day may be an impossibility for you.
That's true. That's very true.
And so you might want to object to it on that basis. If your agreement calls for mediation, for example, do you have to exhaust that mediation before you file your petition for relocation?
Absolutely, because that's within the allocation judgment. That is something that you are ordered to abide to, given the language in the agreement before you go forward in court. So you have to exhaust all your means as outlined in the allocation judgment.
I think one of the things people do is they plan their move, they look for their new home, they take a new job, and then they think after the fact, well, now I got to deal with the issues regarding my child. And they really should be dealing with that at the forefront of the decision making. So there's ample time to get this done, and don't go putting yourself in a financial arrangement without having this completed. Would you not agree with that?
I agree.
Now, I think that's really what one of the changes was in Illinois. And before we get into the factors of relocation, it's my understanding that the law changed effective January 1, 2022. Can you explain that change in the law?
Yes. So before January 1, parents usually had to wait until the end of the case when there was an allocation judgment entered by the court in order to petition for relocation. The reason being is that the courts and the law were interpreting the statute before as there needs to be a final determination as to who has majority parenting time or equal parenting time. As we mentioned before, those are the types of parents that qualify for relocation, whether you have more than 50% or exactly 50% of the time. So usually you have to wait to see how that parenting schedule was going to play out before you could say, hey, I want to relocate to another location.
Sure.
Now, in
January, and not to interject, but I just want to make sure you're talking about pre-decree, meaning
pre-decree.
Got it. Okay.
Right. So then January 1, 2022 rolls around and we have this new law that says, hey, this is becoming burdensome on the parents and the children because there may be these extremely great circumstances that may be best for the child where they need to move because of the education, or maybe their current environment isn't so great and so there needs to be a change, or maybe there's a job that's in place that could be lost if there's no decision made at that time. And so the court considers all of these different burdens and consequences of waiting towards the end of the case to make a decision on relocation. And they said, hey, well, now we can start deciding that on a temporary basis. We can do that before the final determination is made as far as the allocation judgment. So
now,
so it's a temporary, it's allowing parents to do it sooner rather than later.
Sure. And in a post-decree situation, the same is true, because previously the judges wouldn't allow you to move, even if you had majority of parenting time. So you had the standing to be able to do it, but you filed your petition and the other parent was litigating it. And maybe they were asking for an evaluation to be completed, and it could take trial dates to get a full trial by time the GAL, the guardian ad litem, or the child's representative does an investigation. Months have gone by and maybe that opportunity leaves. So this is also true in post-decree cases as well. Isn't that correct?
That's correct.
And I think that's really interesting. It's funny because when I read an article about the change in the law, it said many judges wouldn't allow relocation, but I've had those cases where even on a temporary basis, the judge did allow it. So I think it cleared up also the law that a judge wasn't saying, well, I think this is equitable, and really define what the availability is. So I think that's really important as well. Now, okay, so you file for relocation, you filed your notice, the other parent said no, you went to mediation, the other parent said no. Now you're going to have to file a motion before the court. So are there factors under the law, Keshia, that are required for the court to consider in making its decision?
Yes, there's a handful. There's about 11 factors that the court considers, and it all varies because they may not all be applicable to a person's case, but some factors may stand out more than others. So for example, one of the factors is the circumstances and reasons for the intended relocation. That may always be applicable because the court is always going to want to know why one place is preferred over the other. So in certain instances, there have been some cases before in the past that a primary parent wanted to move out of the city of Chicago because of the impending violence. And there was always, it always seemed to be danger in the location that her and the child were in. And so it was better suited for them to move, 25 miles out into the suburbs, or maybe a little bit further out for her job in Indiana. And so those were very compelling circumstances to the court because there is a certain level of violence in the city that the court recognizes. And so that was a good reason for relocation. Some other factors that they consider is the educational opportunities for the child, what the impact of this relocation is going to be for the child. Is the children going to lose their friends, their community support? Are they going to be moved away from everything they know, family members? Those types of things are considered because those can have emotional and physical impacts on the children. Another thing that they consider is the wishes of the children. That's not always considered if they're under the age of 5 or so. But if you have a child that's 12, they may be very much in tune with the neighborhood. They're part of community programs, and they may not necessarily feel comfortable with moving away from their community or from their other parent if they're in the same area. So it's just a lot of factors.
Right, but just so I'm clear, it doesn't mean that the age of 12 gives somebody, because a lot of people say, well, doesn't my child have the right to make the decision at the age of 12? That's not the case, right?
Right, it's not always, that is not the main factor. I mean, a child can say, hey, I don't want to move, or I do want to move, but it's something that's considered, but it's not the end all be all. So it's not the, there's other things that needs to be considered because a child doesn't always know what's in their best interest. They're just speaking out of emotions, or they're speaking out of their personal feelings towards moving. But sometimes it's really best for the parent to make that decision on their behalf, especially if there's nominal reasons or, some weird reasons why the child doesn't necessarily want to move.
Sure. And it sounds to me that all these factors that we've already discussed, and we want to make it through all the factors, but it sounds like the court's going to look at what's in the best interest of the child, not what's in the best interest of the parent wanting to move.
That's correct.
And I think that sometimes people say, well, I met somebody and now I met them online and I want to move out there and they're going to provide me a home. And therefore, by circumstance, the children gain some benefits for it. But that's not how the court's going to approach that, correct?
That's correct. Yeah, they don't really, I mean, you could have sometimes things that works for the best interest of the children also benefits the parents. So again, the issue of a new job, that's more financial stability that helps supports the child and benefits the parent, right? But if you're saying, I want to move in with a significant other, or I just, picked this place on a map because I thought I heard good things about it, it doesn't necessarily mean that that's the best location. And that's really something that's for your benefit, but the child may not know whoever it is that you want to move in with. It may not feel comfortable. And maybe some issues surrounding that in itself. So just because you want to do something as a parent doesn't necessarily mean that it's in the child's best interest and for their, for their well-being.
Sure. And, you're talking about education, and I know healthcare is also an issue. So for example, if a child has a certain medical condition and they have great doctors in the area, in the Chicago metropolitan area, and you're moving into a rural neighborhood that maybe doesn't have a specialist, that's a factor the court's going to look at as well.
Oh yeah, especially when you have children that have special needs, who have a lot of conditions, severe injuries, things like that, and they need to get to their doctor. And it's, more often than not that they're making these visits and they're ways away from their doctor. That could be an issue as well. So, necessarily moving 45 miles out when their doctor is maybe 5 minutes away from where you're currently living, that can play a huge role in the relocation issue.
Right. And I mean, it's a difference if it's an annual appointment or if it's a weekly appointment. I mean, there's so many different things that can count in. But I find that based upon my experience practicing family law is that a lot of people look at these issues after the fact. They file a motion or they come to you and say, well, I need to relocate. Please file a motion. And you say, okay, so let's compare schools. They don't even know what school the child would be enrolled in the new location.
For sure. It's just one of those things that's like a grand idea that some of the details are just not really worked out. And when you get into the meat and potatoes of it, then you realize that, okay, we need to put some more thought into why this relocation should work out for the child.
Let's talk about a parent who the other parent maybe isn't as involved. So let's say that they were allocated 35% of the parenting time and they never exercise it. So, one parent wants to relocate. Is that going to be a factor the court's going to consider, the fact that a parent didn't even participate in the past?
That may be something that they consider, but if there's been instances that if a not as much, a hands-on parent decides that they want to be more involved in their child's life, or they do want to have that that ability to communicate with the child or be with the child, that could still play a role in the relocation, even if they haven't been there, 24/7 or exercising a lot of parented time. They still have the right to say, hey, I want to be around my child. I want to be in their life, and this is going to impact that.
Sure, because one of the factors the court's going to look at is, can it fashion a schedule that makes sense? So, if you're going to move out of state and now we only have limited weekends where the children may have a Monday off of school or a school holiday or a school break for winter break or spring break. And then you have to anticipate that if that other parent isn't going to be in their lives, they're going to get extended time in the summer. And I hear people say it's not fair. How would you respond to that?
Well, my thing is that, there's already so much, it's already limited time. At some point, there has to be a level of compromise, especially if you're moving a great distance away, that you have to anticipate that you're going to have to be a bit flexible with the schedule. And so if that's doing workarounds with the summer or spring break vacations, you have to learn to get on board, because this is a major decision to make when you're relocating.
Right. And I think the other thing that parents don't often think about is what's really their motivation. I think sometimes people had a bad relationship and now their relationship is over and they want to penalize the other parent by moving away and thinks that that'll break it out. And that will come out in court. Wouldn't that be true?
Mm-hmm.
That's your motivation.
Right. Especially if it seems like, hey, I just wanted to move because, he or she wasn't around anyway, so it doesn't make too much of a difference. Or, you know, he didn't do this, or she didn't do that. And so that's why we're moving this way. That's not, you have to have good faith, or you have to have good intent. And that's one of the main things that the court looks to as well. Is it really in the best interest for the child? Are you doing this with good intentions? Or are you using this as a punitive way towards the other person? So.
Right. And then sometimes, I think that the other parent, when they fight these things, they don't realize the consequence. Okay. So you go to a full relocation hearing and the judge says, I'm not going to allow the child to relocate. But isn't it true that doesn't mean the other parent can't relocate? So maybe the parent with majority parenting time says, fine, I'm relocating, here's the child.
That could happen too. And so sometimes the other parent that has contested the relocation usually doesn't know how to handle that situation because they did not anticipate becoming the primary parent. So now they have to adjust their schedule, adjust their whole lifestyle because they were used to maybe alternative weekends, and now they're the majority parent with 5 days out of the week.
Right.
So you have to plan accordingly. You have to be prepared for every situation in the case that it turns in the other direction for you, or you get the opposite effect.
Right. And I also think that, if you are going to get an evaluation through this process, there is some literature that supports the notion that when the children are younger, having more frequent, shorter intervals of contact with each parent is better. And maybe when they're older, you can do these extended summer times and that can still form the bond. But what's important at the end of the day for the parents to consider is how can each parent have a good relationship with the child, correct?
Correct.
And I think that within that scope is so important because it's not only what can they do to have a good relationship with the child, but, let's look at the extended family that's available to that child. And it's fostering that relationship with yourself and the other parent.
Right.
And how would you talk to a parent to say, before they even consider embarking on this, what should be your first step?
Well, one, you want to go through I would say, let's go through the factors and see if they are applicable in the case. So how, depending on the age of the child, how they feel about the move, whether this is something that you believe that the other parent would agree to. Because if it's something that could be resolved pretty quickly, if another parent doesn't have an issue with it, then that's one way to address it without going through the route of motioning the court. But if you know for a fact that this parent has made it clear that he or she is not going to agree to your relocation, then start thinking about the quality of life that your child would have if you were to move in that location, what the benefits will be to that child. So you can have that at the ready in the case that there is a full-on litigation over this issue. You definitely want to get into the thick of the benefits. You always want to look to the best interest of the child, and you want to know the logistics. How far is it going to be out from the other parent's home? How is it going to affect travel time to and from school? How is it going to affect visits with the other parent and their family? How is it going to affect the holiday schedule? Because more often than not, there is either a schedule being worked out or has already been worked out. And so you need to know how relocation would affect that parenting schedule. And so once you work out the details of that, and if there's no significant change or if there is a major change, you need to work towards a way to resolve that.
And that's so true. And then factoring in, are you going to have to do airfare? Are you going to have a parent accompany the child on the plane? What is that cost going to be? Because in often many cases, if you're the one that wants to relocate and travel to a state on either the East or West Coast, you're going to be bearing the responsibility for that expense for the flight to and from. You're the one that wanted to remove, and relocate that child. So these are things that are important. And what I would recommend to somebody is before they even consider a move is have a consultation with an attorney. We offer free consultations where we go through these factors and say, understand what you're embarking on, because this could be a long wait. It could be a very expensive journey. And now, luckily, we have the ability to have a temporary relocation by statute, but that doesn't mean you're necessarily going to win it either.
Right.
It just means that you have to look at the totality of the circumstances. And look, there's situations in life where you're going to do this and say, I'm going to try, and if I lose, I'll make the decision at the time. But knowing your options is so important to balance the pros and cons and to see where you can come up with a remedy for this situation, I think is key. What else, what other advice would you give somebody embarking on this journey or considering it, Keshia? Anything else?
I mean, definitely consult an attorney, like you said, making sure that you have your ducks in a row when you're working out the details, because it, like you said, it can be very costly. You definitely need to think about whether this is a best move for your child or your children and not just for yourself. And
Don't go out and put a down payment on a house and have to close on
and
it.
don't just do it, because
Yeah.
that can backfire.
Right.
I've seen some cases where a parent will just move because maybe they had the children within their care majority of time, but they're still an active involved parent. And so that's an issue. You can't just move. You need to either consult with the other parent to see if you can get an agreement or petition a court. But just taking that move can lead to other circumstances. So
Right.
definitely consider your next move, your best move.
Right, because if you just do it, you know, if somebody would call an attorney, they're going to file an emergency motion and have those kids returned. Again, nobody cares where you move, but they do care where the kids go. So ultimately, I think that the whole issue here is planning, knowing your rights, and being prepared. So Keshia, thanks for your time today. I think this is important information for people to consider.
No problem. Thank you.